Sir. Officer Hebner?
Yes, hi.
You're Officer Hebner?
Yes.
Oh, you're not the other Officer Hebner that I know. Okay.
No.
Anyways, Officer Hebner, do you know whether or not that person, Ms. Harris, has been interviewed by defense counsel?
She is not yet.
Okay, thank you.
Yep.
Just mute yourself, ma'am.
Okay.
As soon as I have a defense counsel, I'll let them know so they can zoom in and I can put them in a breakout room.
Thank you.
Thank you, ma'am. Ms. Kelly, you can't go outside, at my understanding.
No, I go take everybody out and we can do something.
No, just wait. Because I don't know who's gonna be the afternoon docket. For those people that are in the audience, this is Magistrate Echarte. I don't have all the files, so I'm just letting you know that. Council Perkins, I don't have your client's file.
Okay, all right.
Good afternoon, Magistrate.
Good afternoon, Council Coyle.
Is
Council
anybody
Coyle,
from the prosecutor's office shown up today to do an arraignment?
other than you and Vincent, those are the only two people.
Okay, that's all I'm asking. Thank you.
Ma'am. Oh, who's on Jenkins? That's a Capias.
Mr. Vincent.
Okay, thank you, ma'am. No. $231. Apparently, 231. I got no defense counsel. I got no DDC. Let's see. Maximum felony habeas for Judge Mechanical. Okay, you're gonna be doing the rest?
Yes.
There is a hospital from Harris, Regina Harris, who's chiming in to do the interview.
Ms. Shea, Jessica.
Miss Jessica?
Yeah.
Did she chime in already?
I'll ask her. I'll let you know.
No, I'll ask
All
her.
right, let's go.
No, you can stay right there.
I need to follow you anyways. I gotta go.
Help me with that. Thank you. That part. We brought probably already took it to get the file, right? Was there two? Probably not. I'll just wait dates. Oh, it is over there. Let me get it. I gotta deliver these. Mailbox.
Now, I just need to know that DDC is ready. Hopefully nobody's on camera one from DDC. DDC is not here. Madam Clerk, can you call DDC for camera one? Madam Clerk,
Yes, Your Honor.
can
Okay,
you
just-
call DDC?
Yep, I heard you.
Oh, okay, for
Yep.
camera one.
Register, who's my capias?
Pardon me?
Who's my capias?
Jenkins, number 18. CCW. Oh, not only that, just by you asking me that, that reminded me too, we are on record now. I would really hate to not record and start arraignments. No,
Okay.
that's not a good thing. So we are recording.
Jenkins, capias.
Did you get a hold of DDC? Oh, she's calling
Oh,
right
yeah.
now.
Court. That's on the court. Look, we need you. Is that possible right now?
Yeah. Magistrate Jenkins still has not been interviewed.
Pardon me?
Oh, yeah.
Jenkins, the capias, has still not been interviewed, which is why I was in the office.
You mean
looking for-
Jenkins has not been interviewed?
Yes, has not been.
All right,
That's why I was in there. I was looking for that. He didn't come in.
okay. Go back to that.
Thank you.
I didn't say enough for you to leave.
Oh,
Okay.
Zoom in, Your Honor.
You know, it's one of those days. Okay.
You're walking us in persons,
Okay,
your males, and then this is your female, right?
okay, thank you. All right. Can you let Council Shive? Is that like camera one, camera two,
she's
I'm
on,
not-
she's on the DDC men's camera, at least. Camera
men's
one.
side,
Yeah, men's side.
camera one or
I don't know,
camera
I'll
two?
find out for you.
Go ahead.
Thank you.
Oh, here we go. TDC. Sir, my understanding that number 18 on the list, Jenkins, has not been interviewed yet.
That's correct, Your Honor. He's next to be interviewed by the attorney.
Okay, I need an attorney so that, do you have anybody that's on that they can interview? Is that person in front of camera two or in front of camera two? DDC is,
Ms. Shai is on camera number 2, DDC male side number 2.
Okay,
Copy that.
can you put Jenkins number 18? Is that a? So they can be interviewed?
Yes, Your Honor.
I appreciate it. Thank you. That being said. You're gonna do hospital arraignment?
Yeah.
Okay, all right. Officer Hebner, please unmute.
Hi, ma'am.
Okay, we're gonna do that one. All right. Miss Claudia, stand by for a moment. Can you call a judge for Constables courtroom, let them know that
That's who's on the phone.
is that she is not, the defendant has not been interviewed yet. That's why.
Oh, hold on, wait a second. Okay, good.
We have one.
Just one.
But it's the Judge Holmes case, so can you let, when you get to that person, can you let them know to zoom into Judge Holmes courtroom for that traffic matter?
Okay.
Okay, thank you.
Okay. All right, thank you, Officer Hebner. Thank you for your patience. Could we have Ms. Harris? And whoever's here on Council Clow, Council Stevens, whoever's here on behalf of the hospital, Ms. Harris from this morning. All right. Young lady at the hospital, what's your name, ma'am?
Regina Harris.
Is it Regina Lee Harris, ma'am?
Yes, it is.
Thank you, Ms. Harris. I'm Magistrate at Charles Bair. You're here at criminal matter. You are defendant 2 in this case, case number 220-600-3602. You have an attorney, counsel.
Judge Miguel Rico on behalf of Ms. Harris is appearing today via Zoom. Judge, my husband advised of her constitutional rights, waives her full written complaint, stands mute. Respectfully request that this court enter a not guilty plea on her behalf as to all counts.
Thank you. I'm going to enter a plea of not guilty. Court dates are June 25, 2025, 36th District. Excuse me, June 25, 2025, probable cause hearing, followed by preliminary examination, July 2nd, 2025. Both matters are in front of Judge Giles. Ms. Harris, did you hear those court dates?
Did you
June 25th,
25th
next week, and July 2nd.
and July the 2nd?
Both matters are in front of Judge Giles.
Okay.
Okay, all right, Council Coyle, you're here on behalf of the people?
Lisa Clow, appearing on behalf of the people. Your Honor, people are recommending a 10,000 personal. This is a matter from February of 22, non-assaultive.
Okay, and Council Brickoff, no objection?
No objection, Judge.
All right, bond in this case is gonna be $10,000 personal bond. That means, ma'am, so that if you're in custody, nobody has to pay any money for you to get out of jail. Do you understand that?
You think I could please?
Well, they may have to take you to DDC, however it is, whatever their process is, but on this case, it's a personal bond. Nobody has to pay money for you to get out of jail.
Nobody has to pay money?
No, ma'am, it's called personal bond.
Okay, I understand that. Thank you.
Just go to court, show up, take care of your matter.
Thank you. You write
Thank you,
that.
ma'am.
Okay, you give it the
Thank
time.
you, Officer Hebner.
You too.
Yep, no problem.
Thank you.
Have a good day.
You too.
All right, so that takes care of that. Let's do some of these walk-ins. All right. Brooks. Brooks, come on forward. Perkins. Let's see, 55623. Sir, the one in the, looks like a black shirt. What's your full name, sir?
Antonio Miguel Brooks.
Okay, Mr. Brooks, I'm Magistrate at Chuck there. Case number 250-5812-801. Go ahead, counsel.
Yes, good morning, Your Honor. Excuse me. Good afternoon, Your Honor. Good afternoon to your staff. May it please this honorable court. My name is Todd Russell Perkins, P 55623, appearing on behalf of Mr. Brooks, we waive any formal reading of the warning complaint. I stand on mute. I respectfully ask the court to enter not guilty plea at this point.
Thank you, sir. I'm gonna enter a plea of not guilty. Court dates are July 1st, 2025, probable cause conference followed by preliminary examination, July 8th, 2025. Both matters are in front of Judge Taylor. Mr. Brooks.
He is a walk-in today, Your Honor?
Yes, he's a walk-in. The charge is fleeing. Okay, this is from February 2024. Council Vincent,
Yes,
go ahead with your
Magistrate.
recommendation.
Good to see you, Magistrate. Good afternoon, Steve Vincent for the people, P71917. Magistrate, I have an incident date here in February of 2024. More importantly, though, I have a lien that was entered only about 5 days ago. It appears as though this defendant's taking this seriously. He's retained, highly, reputable, highly respected counsel. It is a fleeing fourth degree, so it's serious, but it's non-assaultive. At this time, we're not going to be objecting to a personal bond with any other conditions you feel appropriate.
Okay, one of the bond condition is there is no driving unless you have a valid license. Do you understand that, sir?
Yes, ma'am.
Okay, and with that said, Council Perkins, you have no objection to a personal bond, correct?
No, absolutely not, Your Honor.
Okay. And, all right, $10,000 personal bond. And sir, that means had you been sitting in jail, nobody would have to pay any money for you to get out of jail. Do you understand that?
Yes, ma'am.
But I am gonna need you to take a seat so that we can get your paperwork to you, okay?
Okay.
Thank you,
Your
sir.
Honor.
Thank you, Your Honor.
Driving. Out license. All right, takes care of that. Let's go. Still waiting on that one. How about Pitts? Is Suzanne Pitts here? Not yet? All right. What's about King? Is Kevin King here? Come on forward, Mr. King. Let's see what we have. Okay, let's see. Case, sir, please say your full name.
Kevin Darrell King.
Thank you, Mr. King. I'm magistrate at Chattat, case number 22044948001, sir. Go ahead, counsel.
Judge Miguel Rico, PA 8379, on behalf of Mr. King today. Judge, my client waives a formal written complaint, stands mute, has been advised of constitutional rights, to receive not guilty plea be entered on his behalf.
Thank you. I'm gonna enter a plea of not guilty. Court date is June 30th, 2025. It's a review court date in front of Judge Bryant. Also see, it looks like that there's capias. Let's see what we have. Capias from June 27, 2023, no show. It looks like bond was set at $100, 10%. Okay, all right. Council Vincent, go ahead, sir.
Thank you, Magistrate. And again, good afternoon, Steve Vincent, P71917. Yeah, this is becoming a pattern with this defendant. He fails to appear. He gets a capias warrant issued. He comes and he posts it. And then the case continues only to do it again. This is the second time around. My hands are proverbially tied right now because it appears as though he's already posted his $10. This is post adjudication. This is just review.
When did he post it?
I have a forfeiture and a posting all in the same time for, I believe it was, I see it in like 2023, but I'll go back just to double check it all.
Oh, because I see July 27, 2023, and it looks like it was forfeited. Okay, so the bond still stays at $100, 10%. Give me your argument.
Well, okay.
Go ahead.
No, if that's what you're seeing and it's $10, I'm not going to argue with you. I had just seen on it that he had previously posted on a prior matter, only for that to be forfeited again for this, then for a failure to appear in a subsequent bond to be issued $10. I had thought based on my reading that he posted it. If you don't see that, then I guess he owes $10 before he can walk out of there.
Well, my reading is whatever was posted was forfeited, so just $100, 10%. You have no argument one way or the other?
Not really. I think this was supposed to be affordable. He walked himself in today.
Okay, that being said, he walked himself in. This is a few years old from 2022. So I'm gonna give him $100 personal bond. And Mr. King, let me say this, sir, is that you can only get so many chances before the bond may be higher and somebody has to pay more than $10 for you to get out of jail. Do you understand that?
Yeah, sure.
So just take care of your matter, okay? You've already gone through the process, whether you pled guilty or whatever, just finish up your case. So it's $100 personal bond. All you need to do, sir, is just take a seat, wait for your paperwork, okay?
Thank you, Your Honor.
Thank you.
That's what time is it on June 30th?
Pardon me?
What time is his hearing on June 30th? His hearing, what time is it?
Oh, I'm sorry. That's at 8:30 in front of Judge Bryant. Yep. And I believe, looks like it's virtual, so it's by Zoom. All right, let's see. Do we have Neely?
Yes, Judge, we do.
Neely ready? Okay.
He's ready.
All right, case number 250-5812-001. Please say your full name, please.
Alexandria Denise Millie.
Thank you, Miss Neely. Go ahead, counsel.
Judge Miguel Rico, on behalf of Ms. Julia, appearing today in person to my right. My client's been advised of her constitutional rights, waives the formal reading of the complaint, stands mute, respectfully requests that this court enter a not guilty plea on her behalf as to all counts.
Thank you. I'm gonna enter plea of not guilty. Court dates are June 27, 2025, probable cause conference, followed by preliminary examination, July 3rd, 2025. Both matters are in front of Judge Giles. Understand both court dates? Okay, just want to make sure. Don't look to him, look to me. Let me know you understand or you don't. Because if you don't, I'll repeat them for you again.
Yes, can you repeat them, please?
Yeah, sure. June 27th. Okay, that's at 8:30. Okay, July 3rd. It's going to be in front of Judge Giles. You're going to get paperwork for that.
Okay.
Okay?
Yeah.
All right. So let me tell you some bond conditions. There's no drinking, no possessing any alcoholic beverages. You understand that part?
Yes.
Okay. There's no assaultive or combative behavior. Okay. While you're on bond on this case, you understand that?
Yes.
Okay. No driving. Okay. So there's no driving, period. Okay, we'll see if that's gonna change or not, but right now there's no driving. You understand that?
Yes.
Okay. Counsel Coyle, go ahead, ma'am.
Good afternoon, Lisa Coyle, appearing on behalf of the people. Your Honor, in this matter, I know she walked herself in. This case dates back, it has a little bit of age. It's from September of 2023. It was issued by the prosecutor's office in December of 24 and signed by the court in June of 25. So there's a little bit of age to it, but it does not lessen the severity of it. We have here that the allegations are that Ms. Neely, driving a Suburban, which is a larger car, a truck, went airborne after. Let me say this: there was a trooper making a traffic stop. He stopped. His lights are fully activated. She strikes the side of his vehicle. She goes airborne. She strikes a second vehicle. The trooper suffered a broken tibia and thumb, abrasions and contusions about the body. He stayed a couple days in the hospital. When they took her to the hospital, and the IR indicates that she suffered very minor injuries, she was extremely combative with the officers, the troopers, and the EMS personnel. She was, "Don't touch me, let me the F go." They noticed she had a strong odor of intoxicants about her. They described her as belligerent and hostile. She resisted cuffing. She told the troopers, let me the F out of these cuffs right now, and so forth. Her blood results came back at a 0.152. Your Honor, this matter, and the reason if this were closer in time, I would be asking for a high cash bond in this matter. This is why drunk drivers cause not only everyday drivers a danger, but also state troopers and other police personnel that are doing their job as they're supposed to. And that's why he had his lights activated. She becomes a weapon in that Suburban. And when she struck the officer and struck the other, he's in a Charger or he's outside of his Charger and outside this car, and then struck the Chrysler. Her car went airborne, so she is moving. So based on her high blood level of alcohol, based on her actions, after, Your Honor, she does prove to be a danger to the community. So I am going to ask you keep that condition of no driving. I know some time has passed. She's been lucky that the case has moved so slow, but things have changed now. Now it's time to start the case and face the consequences of whatever they may be of her action. She is presumed innocent at this point, but things have changed now that the case is before the court here. So based on that, I'm asking, as I know that it's unusual for asking for a cash surety bond in a walk-in, but it's not flight risk. This is a danger to the community risk. So I'm asking for a 25,000 cash surety bond only because of the time that it's passed. Otherwise, I'd be asking a larger amount. I'm also asking for an alcohol tether. And I know the time has passed, but I think that an alcohol tether, based on the allegations before the court, is imperative as well as the no driving condition. Thank you.
So let me ask you this, Council Coyle. Does she have any other prior drinking and driving convictions
Not that
or
I'm aware
pending
of.
cases?
Not that I'm aware.
Okay. Go ahead, Council.
Judge, on behalf of Ms. Neely, I would object to any amount of monetary bond. Any amount of monetary bond would be unaffordable for my client. Judge, just to touch on the two aspects that the state had mentioned, I understand that my client poses no flight risk. There's currently a civil matter due to this case that she's been attending diligently. She was currently at 36 today on a civil matter in which they informed her of this warrant. That's how she was made aware of it, stayed outside my office until we had an interview and learned of her charges today. And even after learning of the severity of her charges, sat down, waited patiently, is ready to be arraigned on the matter, even after I explained to her the risk associated with these kind of charges, potential time, pretrial detention. In addition to that, Judge, I understand the argument of danger to the public. Quite some time has passed. This is from September of 2023. Since then until now, my client indicates to me that she's had no criminal interactions. She's had no drunk driving interactions. She's had nothing happen since that time until now. And prior to that time, I believe nothing has occurred. So for her to be a danger to the public from that instance that happened over a year ago, about a year and a half ago, if my estimates are right, I don't think she's a danger, Judge. I don't think that putting her into pretrial detention based on the danger argument is warranted. She does work. She works at Sinai Grace. She's a housekeeper. She has been there for 7 months. She is full-time. She has 5 children. All 5 of her children live with her as a sole caretaker in the city of Detroit, in which she has been a resident all of her life, Judge. I don't see any reason why she won't show up to court. She's showing up on the civil matter related to the same incident. She shows up on all her other matters at this court that are civil. She's not a flight risk. I do not believe she's a danger. And the instance in which she's presumed innocent, I can agree with this court that the factual allegations made against her may appear that this individual is dangerous, but she's presumed innocent of those. Nothing has happened before those. After those, we just have the date in question. I would be requesting a personal bond from this court. I would be requesting no alcohol tether. She has no other alcohol-related instances in her past or from that event until now. And that's what I'd be requesting from this court today.
Okay,
Judge.
I'm sorry. Tell me what you were requesting. I know you're requesting a personal bond.
Personal bond without alcohol tether.
Without.
Without.
Okay. Well, first of all, had this been in September of 2023, had this been November 2023, December of 2023, she is a danger. At that point in time, a danger. Whether or not she's a flight risk, I don't know. A danger, yes. She injures another individual. Allegedly, she is obstructive or she's assaultive. Okay. But We're not back in 2023. We are here in 2025. I believe a little more than a year and a half has passed. I don't hear anything to indicate that she has any other pending cases. Okay, I don't hear that she has any prior convictions or instances of drinking and driving or drinking, period. I don't hear any of that stuff. So let me say this for you, Miss Neely. You're caught with a beer in your hand, in your car, whatever it is. You're caught with a beer, any type of alcoholic beverage. That's violation of your bond condition. Do you understand that?
Yes.
Okay. If you are moving a car from in front of the house to a parking spot, that's a violation of your bond condition. Because no driving also means no operating. You can't sit in the driver's seat and start the car. Do you understand that?
Yeah.
Okay. And no assaultive or combative behavior means is that, okay, you can't be physically assaultive. And you know what? You can't start yelling and screaming that you may get somebody else afraid of you because of your actions. That's what the no assaultive combative behavior means. Do you understand that?
Yes.
Okay. So you walked in. At minimum, that tells me that you're serious about the case. Okay. So. And I would have said, and I would have agreed with Council Coyle. Probably your bond, had we been sometime in 2023, your bond would probably been maybe $100,000 cash surety. But because you're here now, and from what I understand, and I'm looking at it, this case was not authorized until June of 2025 by the prosecutors, and it was not authorized by judge or magistrate June 12th, 2025. So I don't have anything new. So, ma'am, I'm going to give you $100,000 personal bond. Please don't make me regret this. The ball's in your court. Any violation, don't come pleading, because you're already aware of what your bond conditions are. You're already aware of your court dates, correct?
Yes.
Okay, $100,000 personal bond. Do me a favor, take a seat, wait for your paperwork.
Judge, we are running on the one KPS for chief.
Okay. DDC. Can you unmute?
Can you hear us, Your Honor?
Sir, can you put Jenkins, let's call, where did I leave my, here we go. Jenkins in front of the camera.
Courtroom 533, Saran speaking.
Yes, ma'am. This magistrate at Charter, can you inform Judge McConico that we are looking for Jenkins to be in front of the camera? That person's already been interviewed.
Is he in front of the camera, Your Honor?
Yes, he is right now. I have somebody.
Okay, I'll let him know.
Thank you. Gentlemen.
Thank you.
Thank you, ma'am.
Okay.
Bye-bye. Gentlemen at DDC, what's your name, sir?
I'm Mario Q. Jenkins.
Thank you, Mr. Jenkins. We're waiting for Judge McConico. Do we have a Pitts that's been interviewed?
Yes, Joe.
Okay. Come on forward. I will say this, Judge McConico comes in, we're gonna stop. Okay,
As you please.
all right. What's your name, ma'am?
Suzanne Pitts,
Full name?
Suzanne Marcia Pitts.
Thank you, Ms. Pitts. I'm magistrate at Charter, case number 240-4499701. Council Burkhardt, wait for my reading, stand mute.
Yes, Joe.
I'm gonna enter a plea of not guilty. Court date is June 27, 2025. It's pretrial for the Judge Bryant. Okay. Council Coyle, go ahead, Esteban, please.
Mr. Coyle appearing on behalf of the people. No objection to 5,000 personal.
Ma'am, you're gonna get a $5,000 personal bond, and I believe your attorney who's standing to your left is not objecting. Correct, counsel?
Correct.
Okay, so ma'am, all you gotta do is just take a seat, wait for your paperwork, okay? Thank you, Counsel Coyle. That was a fast one.
Judge, I have Mr. Dosey's family appearing in person today in support, just so you know he's with us today.
Okay, hold on. Okay. Not gonna do anything until we have Judge Mechanical. Ladies, can you tell me on Brooks, what was the bond that I gave? Brooks, that was with Todd Perkins. How much?
10,000.
Thank you. Just write it down.
What's happening?
Mr. Jenkins, just be patient. Council Brico, you're gonna be handling the rest?
Yes, Judge.
Okay.
Fifteen on the list, Carhan is in the hospital. We're trying to get on with an interview about Docket.
Is a hospital?
He's in the hospital.
Really? Okay,
I don't know what gender.
yeah. Kareem is usually a male, but I don't know. I know. Okay. Oh, here we go. Mechanical, there we go. See. Mr. Jenkins, please say your full name.
I'm Mario Q. Jenkins.
Thank you, sir. I'm Magistrate Chartea. Judge Mechanical is here. Case number 250-580-2501. Charge is count one, carry concealed weapon, motor vehicle. KPS is June 16, 2020, June 16, 2025, $1,000, 10%.
Appearances.
Just for the record, I have 10,000, 10%. Steve Vincent for the people, P 71917.
Good afternoon, Chief Miguel Rico, P88379, on behalf of Mr. Jenkins. My client's been advised of his constitutional rights, waives a form of written complaint, stands mute, requests a non-guilty plea be entered on his behalf.
Not guilty plea will be entered in. Argument.
Chief Judge McConicle, always a privilege. I see here the defendant didn't even make it to his PCC. And as you know, that's a Zoom. He didn't make it to his PCC. He was arraigned on the 7th. His PCC was on the 16th. That's when Judge Robbins gave him a 10% He's 20 years old. Yeah, Chief Judge, I'll leave this one up to you. He didn't even make it to Zoom.
Defense.
Just for the record, I have the ROA pulled up. It is stating to me $1,000, 10% as his bond amount. And defense of Mr. Jenkins on this, the amount of bond is unaffordable for my client. This is a non-assaultive charge, a concealed charge. If you read into the report itself, it was in front of you, I don't know if it is or not. It was a traffic stop allegedly. He was taken without incident, caused no issues with the officers, complied with all orders. When asked why he would miss that court date, to be candid, Judge, he just explained to us that he didn't get anything when he left the jail, paperwork-wise informing him, and he just didn't know which court date it was for. Not an excuse. We do advise all our clients to check on 36th District website to make sure their court dates. But in this matter, I am going to inform this court the amount of bond on the case is unaffordable. That is a non-assaultive crime. My client does have ties to the city of Detroit, lifelong resident. I request that he exit the DDC today on a personal bond. Give him one more chance to show up to his court hearings, Judge.
Magistrate Tretalia, what do you have for the bond?
$1,000, 10%. It's on the capias.
Okay.
Yeah, I'll stipulate to that after a reread of it.
Okay. All right. Court haven't heard the arguments of counsel. Court finds that the 10% bond is an unaffordable bond. Court is going to reduce the bond to 1,000 personal with a GPS tether, 10 p.m. to 6 a.m. curfew, and all other conditions that were in the capias bond. Thank you.
Thanks, Judge.
Thank you, sir.
And is that all, Magistrate Tretalia?
Yeah, this is only one. Thank you
Okay.
very much for your patience.
Thank you.
Thank you. Okay, Mr. Jenkins. So no firearms or any other additional dangerous weapons, as Judge McConicle said, GPS tether, curfew, writing it down, 10 p.m. to 6 a.m. You understand all the bond conditions, sir? Mr. Jenkins, do you understand all the bond conditions?
What's the bond?
$1,000, personal bond. You're not to possess firearms or any other dangerous weapons. Curfew, GPS tether, 10 p.m. to 6 a.m. I'm going to give you the court dates right now, so I don't forget, which is June 25, 2025, probable cause conference, followed by preliminary examination, July 2nd, 2025. Both matters, I believe, it's in front of Judge Robbins. Do you understand everything I've said so far, sir? And you understood everything Judge McConicle said? Counsel Vincent, is there anything else you wanted to add?
No, thank you, Magistrate.
Counsel Brickoff, anything else you wanted to add?
No, Judge, thank you.
All right, that concludes the arraignment of Mr. Jenkins. DDC, we can go down the list unless you have something else.
Thank you.
This way, James, this way, next way, straight down. Good message.
All right, let's see who we have. What's your name, sir? I'm sorry, give me your name again.
Dozy.
Thank you, Mr. Dozy. Mr. Dozy, I'm Magistrate at Tretalia. You're here, criminal matter. Case number is 250-4514001. Is it J1 Santel Dozy? Thank you, sir. Counsel Rico, you wait for me reading, stand mute.
Yes, Judge, my client's been advised of his constitutional
Constitutional rights. I forgot to add that. Thank you, sir. I'm going to enter a plea of not guilty Court date is June 30th, 2025, pre-trial in front of Judge Jones. Mr. Dozy, let me give you some bond conditions. One, you're not to have contact with the Douglas Adams Jr. I put that junior. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Further, you're not to possess any firearms or any other dangerous weapons. Do you understand that? Everything I've said so far, sir? I can read your lips that said, yes, ma'am, but I didn't hear you say that.
I'm sorry, yes, ma'am.
Okay, so Counsel Coyle, go ahead, ma'am.
Lisa Coyle appearing on behalf of the people. The co-defendant was arraigned this morning, got a 25,000 personal, same conditions, no contact with Mr. Adams or the Corbett Street address. This Mr. Dozy here before the court has no criminal history that I am aware of, Your Honor.
So Counsel Brico, any objection to the personal bond?
No objection to the personal bond, Judge. I did hear the corporate address.
Yeah.
That wasn't one of your conditions. Are you considering making that a condition? If so, I would have an argument to make. I do have Mr. Dozy's mother and his grandparents here. His grandfather, who is blind, that resides at that address, in which Mr. Dozy goes to and attends to assist him with day-to-day activities. They are here in the courtroom today, sir, in support of you. I just wanted to state that so he was aware as well.
Okay, so he's got family here. Counsel Coyle? Okay. You don't want him going to the Corbett block at all?
Well, I think that's the same condition that was given to the co-defendant, Your Honor, because this is an argument over the dog that's in the neighborhood.
And the difference being my client is on the misdemeanor charge here today. I believe the prior that they're speaking about, he was charged with a felony, Judge. So just to bring that to your
Okay,
attention.
all right. Let's see. The other one. Dozy, that was a felonious assault. And they were not supposed to go on the street at all. Okay. And you don't want them going to the street or going to the street at all, correct?
That's what I'm asking for. Yes.
Okay.
Right now.
All right, so
But Judge, as to that condition, the state of Mr. Dozy is here. I understand that we have a similar conduct that occurred with a different defendant. However, that being a felony, my client being here for the misdemeanor charge of assault and battery. His family is here. They came specifically here in support of him and to request to me to explain to this court, which I know are one of the factors we can consider under MCR 6.106, that he does attend that home for family caretaker reasons. He understands to not have contact with the complaining witness. I believe that can be achieved through a no contact order while still allowing him to visit his grandparents and tend to his grandfather as he has been doing, Judge.
Okay.
He does have lifelong ties to the community, lifelong resident of the state of Michigan. It's indicated to me that he has no prior criminal history. He has no pending cases, probation or parole. He does work as a security guard, and he really is just, in a situation that I hope gets resolved quickly for him. But if it takes a little bit of time, as these things tend to, I hope that he will be able to continue visiting his elderly grandparents, and one of which is relying on him for certain needs, Judge.
Your Honor.
question. What I want to ask this question, maybe either of you know it. What's the distance between 13,390 and 13,374? Is there a house between them? Or are they next door to each other?
I'm not sure of that. I'm sure we'll be able to ask someone, but Mr. Dozy, we'll only ask you if we want to ask you. Please don't say nothing right now. Would you like me to ask Mr. Dozy?
Yes.
Mr. Dozy, what's the distance between those two addresses?
It is a full residence. A house, basically, a house.
A house between those two addresses?
Or are they next door to each other?
Okay, so you guys, those are not next door homes. Okay, thank you.
How many houses are in between?
How many houses are in between?
One. Okay. Go ahead, Counsel Coyle.
Well, when you read the IR, it's this defendant here that basically is the initiator. It says that he claims that, let me read it here, that there was the physical altercation between him and the complainants, and that he swung on him, and that the issue has been for a while with the dog, and while arguing, allegedly the complainant walked up on his, swing on him, so he reacted with self-defense. So the argument is really between him and the complaint and the dog. And the reason is that the reason he shouldn't be over there because it's about the dog put on the lawn. Okay. So he's the one who has the motive to start the fight and to continue the allegation. And the grandparents are here. That's wonderful. And they can support him all the way. But they're obviously able enough to make it down to court that they can do until the court has a time to the next pretrial in which the prosecutor can speak to the complainant and get a little bit more lay of the land as to the dangerousness of what's been going on. This is not a one-day thing that it just happened, that it started. This has been going on for a while. So putting him back now where charges here, now both are charged, both the cases are going forward, that's when things may amp up a little bit. And so for this condition, at this moment, I'm asking for him not to go over there on that street until a further court, maybe they can speak to the complainant and see what the living conditions are like and what he feels at this point in time as to dangerousness. But this is the reason, he is the reason about the dog that this all started. So that's my point of not having him go over there at this point.
Go ahead,
Judge,
counsel.
I'm sorry to keep hammering on to the point of it. I don't read much into these factual allegations because I take them what they are, allegations. But on the last page of our incident report, we do see that the complaining witness, Mr. Adams, stated that he got out of his vehicle, and once he reached the porch, all three mentioned individuals began to strike him. So he was in fear. He exits his vehicle. He walks onto their property, walks onto their porch, and then is the one that is in fear of everything going on. And then we're going to tell the people that are sitting on their porch at their home lawfully to not go back to that place because somebody came on their property and approached them and they got arrested for it. I don't know, Judge. I don't see him being a risk to the complaining witness if he was given a no contact order and strictly told not to interact with him or with that specific address. I think it'd be completely fine for him to go back to that address. And to the comment about his grandparents taking care by themselves, they're assisted by their daughter. There is no way his grandparent is blind. He's legally blind. He's walking with a cane here. There's no way he's doing this on his own. He was assisted with obviously one of his children. And Judge, this is my only request, and I know that we're belaboring the point. And it's just something that I want to do in advocacy for my client and his family. I would like for him to be able to visit his grandparent during the pendency of this case.
Thank you. I've heard the representations, both sides in this particular matter. I'm not gonna give Mr. Dozy a no contact with that block. He is getting a no contact with that house, which is 13374 Corbett. didn't hear any information further to indicate that he had any other assaultive, that he has any assaultive history. So, Mr. Dozy, there is one house in between your grandparents' house, which I assume is 13390 Corbett. So you should be not 13374. If there is something to indicate that you are approaching that violation, bond condition, you make contact with with Mr. Adams, violation of your bond condition. I'm giving you a chance, sir. No eye contact, no person contact, or through third parties. Do you understand that, Mr. Dozy? And I read your lips said, yes, ma'am. Because any violation, sir, bring a toothbrush because next time somebody's gonna have to pay money for you to get out of jail. Do you understand that, sir? All right. That concludes the arraignment of Mr. Dozy. $25,000 personal bond.
This way, though.
What's your name, sir? What's your name? Is your last name Stewart?
Yes, ma'am. Can you hear me?
Okay, is it Jamar Donnell Stewart? Okay, thank you, Mr. Stewart. I'm Magistrate H. Theater. Not only are you here on a criminal matter, but you're also here on misdemeanor matters. These are misdemeanor matters that you did not show up for court. You're gonna get a personal bond. We're gonna recall the warrant. Nobody has to pay any money for you to get out of jail. The maximum penalty on each misdemeanor is up to 93 days jail and or $500 fine. You understand everything that I've said so far, sir?
Yeah.
Okay. First ticket is P 1253898, driver license suspended, repeat offender, improper plates. Next ticket is P 1399686, driver license not valid, improper license. Next ticket is P 1481832, driver license suspended. Next ticket is P 1491016, driver license suspended, repeat offender. Next ticket is P 1508178, driver license suspended. Next ticket is P 1601766, driver's license never acquired, no insurance misdemeanor. Next ticket is P 1610471, driver license suspended, repeat offender. Next ticket is P 1611233, driver license suspended. Next ticket is P 1602066. Both of these are civil infractions. Next ticket is P 1610422, civil infractions. Next ticket is P 1627377, driver license suspended, repeat offender, no improper plates. Next ticket is P 1660517, driver license suspended, repeat offender, no insurance misdemeanor, driving under a untitled vehicle. Next ticket is P 1660529, driver's license never acquired. And the last ticket is P 920540, driver license not valid or improper license. So I'm gonna enter a plea of not guilty. Court date is July 8th, 2025. Free trial in front of Judge Archer. Mr. Stewart, you have a right to remain silent. Anything you say, orally or writing, it can be used against you before the law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, sir?
Yeah.
Okay, we go for the criminal matter, case number 2505821-601. Please say your full name.
Donnell Stewart.
Thank you, sir. Counsel Abrikoff, you wait for Marine and stand mute, and he's been advised of constitutional rights.
Yes, Judge, requesting not guilty plea on the matter.
Thank you. I'm gonna enter a plea of not guilty. Court date June 30th, 2025, probable cause conference, followed by preliminary examination, July 7th, 2025. Both matters are in front of Judge Chakay. Let's go over some bond conditions, Mr. Stewart. Let's see, you are not to possess any firearms or any other dangerous weapons, whether they're real or fake. No firearms of any kind or dangerous weapons. You are not to go back to the Techpert location. You are not to have contact with Camilla Martin. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Let's see what else. Okay. Counsel Vincent, go ahead with your recommendation, your argument.
Thank you, Magistrate Stevenson, P 71917. Here, Magistrate, we're not going to be objecting to a personal. We are going to be asking for a tether. Tether for the reasons basically in the entirety, the destruction that the defendant caused, the threats that he made against the complainant, as well as that use of the alleged firearm or fake firearm or whatever it was. In addition to that, I have a substantial domestic violence history. There were police reports made by this complainant against this defendant. November 16th of 24, September 18th of 24, May 27th of 24, May 31st of 23, and April 25th of 2023. So this is one of the latest incidents that these two have been involved in. Unfortunately, in this particular incident, it was what I would argue is very dangerous when you have threats being made by this defendant, as well as the use of that firearm or fake firearm, whatever it is. That's why we're asking for the tether, but we're not objecting to the personal. In addition to that, I have a 17 CCW as well as an 18 fleeing third in terms of prior convictions.
Go ahead, Council Brickoff.
Judge, as to the personal bond, no objection. As to the other requirement, I'll leave it at the discretion of this court. It's my duty to argue against it within reason. I believe it is a reasonable argument made by the people on that matter, so I'll leave it at your discretion, Judge. I would just ask that it does not come with a home confinement restriction if you were to impose a tether. My client is a lifelong resident of the state, does have a job, works full-time, Monday through Friday.
So my understanding, you tell me that he works.
Yes, he does.
What does he do?
Judge, I have factory worker on my paperwork. Our interview had not mentioned the specific name of the job. 8 a.m. to 4 p.m. Monday through Friday.
I'm sorry, so you say that he works, you don't know what it is?
He's a factory worker.
Okay, where does he work?
I don't know, Judge, I can ask.
Go ask.
Mr. Short, where do you work at?
Part-time construction.
Say it one more time.
Part-time construction.
Part-time construction. Is it
Okay.
for a company?
It's a medical company. I don't know.
Okay, thank you.
So he doesn't know the company?
Yes.
Okay, does he know the company that he's working
Mr.
for?
Short, do you know the name of the company that you work for?
One thing. It's called Matter. I don't want to say the wrong name, but it's Metal LLC company, something like that. I don't know if I pronounced
Okay. All right,
it. Matter company.
okay. Anything else? Okay, all right, heard the testimony on both sides, this particular matter. He's gonna get a $25,000 personal bond. He's gonna be placed on a GPS tether. Okay, and it's a little bit iffy on about the work, so he's gonna be under house arrest. And I'm gonna let whoever his attorney is approach Judge Jacquet as to the issue about house arrest condition on the GPS tether.
Judge, may we have you a curfew from 6 p.m. to 7 a.m.?
Now, again, all the bond conditions, GPS tether, house arrest, $25,000 personal bond. Thank you.
Brian Bell.
What's your name again, sir?
Alice Bryant, ma'am.
Bryant. Mr. Bryant, I'm magistrate at Chapter. Your criminal matter case number is 250-582-1501. Mr. Bryant, is it Dallas Gabriel Bryant?
Ma'am.
Thank you. Counsel Breakoff, you wait for Marie to stand mute, and he's been advised of constitutional rights.
Yes, Judge, requesting a not guilty plea.
Thank you. I'm gonna enter plea of not guilty. Court dates are June 25, 2025, probable cause conference, followed by preliminary examination, July 2nd, 2025. Both matters are in front of Judge Robbins. Mr. Bryant, while this case is pending, you're not to possess firearms or any other dangerous weapons. You understand that, sir? Okay, Counsel Coyle, go ahead, your argument.
Lisa Coyle, appearing on behalf of the people, no objection to a 5,000 personal bond. This is non-assaultive. I'm not aware of any criminal history, no capious history for Mr. Bryant.
Okay, that being said, my understanding is your attorney is not gonna object, so you're getting a $5,000 personal bond. Nobody has to pay any money for you to get out of jail. Just go to court, handle your matter, sir. Handle your matter. That concludes your arraignment. You can step aside, sir. We missed one?
They added one, they said, I guess she was
We did three
He had
cases. They had another case. Okay, thank you, ma'am. Council Rigoff, there's an Eric Tracy case. He was from this morning. They found another case on him.
May we have the complaint for that one?
That's the one Jessica
Oh,
just
she
came
just,
in.
okay, thank you guys.
Mhm.
Everybody works so good here together.
Okay, all right.
I'm the odd man out. Thank you.
The gentleman in black, sir. DDC, can we adjust the camera? Okay, there he is. What's your name, sir? JC Hood? Thank you, Mr. Hood. I'm Magistrate Chartaster. You're here on a criminal matter, case number 250-579-4401. Council Breakoff, you waive formal reading, stand mute. Has he been advised of his constitutional rights?
Yes, Judge, Council Brico.
Okay, thank you. I'm gonna enter plea of not guilty. Court dates are June 26, 2025, probable cause conference, followed by preliminary examination, July 2nd, 2025. Both matters are in front of Judge Jefferson. Mr. Hood, did you understand the court dates? Do you want me to repeat them, Mr. Hood? Okay, June 26th, it is a probable cause conference. July 2nd, preliminary examination. Both matters are in front of Judge Jefferson. Do you understand both court dates? Is that a yes?
Okay,
Okay, all right, Mr. Hood, you will get some paperwork at some point in time giving you your court dates. Do you understand that? Okay, Mr. Hood, let me give you some bond conditions. One, sir, you're not to possess any firearms, any other dangerous weapons, and that includes bricks. Do you understand that? Sir, you are not to have contact with a Timothy Stevens. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. And the last bond condition, sir, there's no assaultive or combative behavior. Mr. Hood, do you understand all bond conditions? Okay. Council Coyle, go ahead, ma'am.
Lisa Coyle, appearing on behalf of the people. Your Honor, he does have a record from the late 80s and the early 90s for armed robbery. But the last case I see is a felony drug case. People would have, based on the age of this warrant being over 6 months old, based on the fact that Mr. Stevens is homeless, but they did track him down for a note June 1st. No objection to the bond conditions. I'm asking for a 25,000 personal with those conditions. And I would also include as a condition, no use of a screwdriver as well in an assaultive manner.
Okay, so, Mr. Hood, you're gonna get a $25,000 personal bond. Nobody has to pay any money for you to get out of jail. But along with, okay, in terms of dangerous objects, you can't use any tools. You can't use a brick. You can't use a baseball bat. No pepper sprays, no brass knuckles. Anything that can be used as a weapon, you cannot use or possess. Do you understand that, Mr. Hood?
yes.
Okay. So again, $25,000 personal bond. And Council Coyle, was that it?
Yes, thank you.
Thank you. Council Brico, was that it?
Yes, Judge, I have no objection.
Okay, thank you. Sir, you can step aside.
Sean Neal.
I'm sorry, what's your name?
Neal.
Rayshawn Alexander Neal.
Correct.
Okay. Mr. Neal, this is Magistrate H.R. Thasser. Not only do you have a criminal matter, sir, but you also have misdemeanor matters. Some misdemeanor matters where you did not show up for court, you're gonna get a personal bond. Nobody has to pay any money for you to get out of jail. We're gonna recall the warrants. Maximum penalty on each misdemeanor, sir, it's up to 93 days jail and or $500 fine. Do you understand that so far? All right. Let me tell you what the tickets are. First one is P101-1165, driver license not valid or proper license, no insurance misdemeanor. Next ticket is P107-2872, driver license suspended. Next ticket is P1122432, failed to display valid operator's license not on person. Next ticket is P1128536, no insurance misdemeanor, driver license not valid or improper license. Next ticket is P1298108, driver's license never acquired. Last ticket is X2044090, no operator's license. Court is going to enter plea of not guilty. Your court date is July 8th, 2025. It is a pretrial in front of Judge Millhouse. Mr. Neal, you have a right to remain silent. Anything you say orally or in writing, it can be used against you in a court of law. You also have a right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Do you understand those rights, sir?
Yes, yes, ma'am.
Thank you, sir. All right. We're gonna go to, we're gonna go to the criminal matter. Okay, Mr. Neal, case number is 250-579-3801. Please say your full name, sir.
Alexander Neal.
Thank you, sir. Council Breakoff, go ahead.
Council Rico, on behalf of Mr. Neal, my client advises his constitutional rights, waives the form reading the complaint, stands mute, requesting not guilty to be entered on his behalf.
All right, okay, I'm gonna enter plea of not guilty. Court dates are July 1st, 2025, probable cause conference, followed by preliminary examination, July 7th, 2025. Both matters are in front of Judge Taylor. Mr. Neal, let me give you some bond conditions. One is you're not to possess firearms or any other dangerous weapons. Two, you're not to have any contact with a Michael Austin. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. And you're not to go to the, let's see, nope. All right. Go ahead, Counsel Vincent, argument.
Thank you, Magistrate Steve Vincent for the people, P71917. Relatively recent incident. I have it occurring in late May, about 3 weeks old. I do have a defendant who just pled to domestic violence July 25th of 2024 over in 50th District. Ended up getting probation on that. Here it appears as though the defendant's actions were in response to a complainant who may have allegedly assaulted him prior. So this was retaliation. This defendant allegedly aimed a firearm at that individual. It's a neighbor dispute, and then fired the gun that he had in his possession up in the air multiple times. We're asking for a 10%. You've already issued a no contact. We believe this defendant is a danger. One, using firearms in a neighborhood, aiming it and then firing them creates a danger in and of itself. So he's being charged with the FA. We're asking for the cash. We appreciate the no contact.
Thank you. Go ahead, Counsel Breakoff.
Judge, on behalf of Mr. Neal, Judge, for any amount of monetary bond, any amount of monetary bond will be unaffordable for my client. I understand the severity of the allegations made against Mr. Neal. We've explained to him since this is a neighborly dispute and there are some relation between them, and that he would probably not be able to go back to that address. This court hasn't ordered that, but he has told me that he will willingly stay at a different home if need be to prevent any issues arising due to the recency of this event. In addition to that, Judge, he is a lifelong resident. He does have 3 children. He lives with his brother currently, and I'm aware this court mandates that he will stay somewhere else in the meantime. I don't have any prior criminal history other than what the state has stated for the record. I believe that Mr. Neal understands to show up to his court dates, and I believe that the risk to the general public is not at large. I believe the risk to the complaining witness can be mitigated through that no contact order, either with him himself or with that address or with that street judge. So I would ask for a personal bond on the matter and not keep my client in pretrial detention due to money reasons.
Well, on this particular matter, this was just a few weeks ago. Allegation, court used clear and convincing evidence standard when it's a monetary bond. We are started out with personal bond basis. Okay, supposedly he is at his residence or his brother's residence, whatever it is, on Stout. However, allegation is that pointed firearm at Mr. Austin. It appears supposedly that there is also supposedly that there was a prior assault.
Yes, Mr. Neal had jaw surgery due to that prior assault.
Okay, that supposedly he was assaulted by Mr. Austin.
He informed me that he has a follow-up surgery as well.
So does he have medical appointments?
Judge, I just have that, he states that he had to get surgery and still has to go and get follow-up. So I did not.
You know when?
No, Judge, I don't.
And Council Brickoff, I believe you made some sort of argument that the community is not in danger, of Mr. Neal. Well, the complainant is part of the community.
Correct.
But not only that, but when a firearm is used and shots are fired, whether it's at an individual or if it's in the air, those bullets got to come down. And if those bullets come down, then whoever is in the community, okay, can be in danger of those of the bullets coming down. So court does find that he is a danger. Okay, the court is going to go with the $10,000, 10%. I believe that was the recommendation. Correct, Council Vincent?
Yeah, it was. Thanks, Magistrate.
And Council, my understanding is it's unaffordable, correct?
Right.
Okay, so that means, Mr. Neal, you're going to get another court date, which is going to be this Friday, June 20th, 2025, 9 o'clock in front of Judge McConigal, who's going to look at the bond amount and bond conditions. Do you understand that, sir? Do you understand what I've said so far, sir?
Yeah.
Okay. Okay. $10,000, 10%, and the other bond conditions that the court has set. Thank you. Thank you, Mr. Neal. That concludes your arraignment.
Good. Go to work how can I pay y'all if I don't go to work?
Mr. Neal, go ahead, Counsel.
Mr. Neal, this is your attorney speaking. I'm sorry, the magistrate has imposed the bond. We can't argue it right now. You will have another hearing with the chief judge of this court on Friday, where we're going to re-argue for you again to try to get that down to a $0 bond, okay? But in the meantime, we can't do anything. Please don't talk about your case with anybody in the jail or on the jail phone. Just remain quiet until we get you out of there, please. Thank you.
Sir, what's your name? Full name?
Your Honor, my name is Daryl Brown.
Is it Daryl Dwight Brown? Mr. Brown, this magistrate is up there. Not only do you have a criminal matter, but you also have a couple of misdemeanor matters that you did not show up for court. We're gonna recall the warrants. You're gonna get a personal bond. Nobody has to pay any money for you to get out of jail on these misdemeanor matters. The maximum penalty on each misdemeanor is up to 93 days jail and or $500 fine. The ticket number is P1708557. Count 1 is no insurance misdemeanor. Count 2 is driving license suspended. I'm gonna enter plea of not guilty. Court date is July 7th, 2025. Pre-trial in front of Judge Yancey. Mr. Brown, you have a right to remain silent. Anything you say, orally or writing, it could be used against you in court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, sir? All right, let me give you the criminal matter case. 250-5811401. Please say your full name, sir.
Mike Brown.
Thank you. Counsel Breakoff, you wait for Marine, stay mute, and he's been advised constitutional rights. Is that correct?
Yes, Judge, requesting not guilty to the under.
Okay, I'm gonna enter plea of not guilty. Court dates are June 30th, 2025, probable cause conference, followed by preliminary examination, July 7th, 2025. Both matters are in front of Judge Shakay. Mr. Brown, let me give you some bond conditions. 1, you're not to possess any firearms or any other dangerous weapons. 2, you're not to have contact with a Patsy Duke. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Let's see what else. Counsel Coyle, go ahead, ma'am.
Lisa Coyle, appearing on behalf of the people. Your Honor, the people are requesting a 10,000 cash surety, no contact with the complainant, Ms. Duke, in which he has a child in common. I do note that this goes back to November of 24, was just recently issued by the court. I would ask for a higher based on the time though, but in this situation, the allegations are serious that allegedly punched her in the chest. He strangled her, holding her over the front porch rail, strangling her doing that. Then he pulled her up and then he punched her in the mouth. Officers did observe injury. They observed her cut lip. I do note there was a prior domestic violence second charge in which there was a bench trial, same victim. He was found not guilty in that matter. That was in September of 2023. I do note that he is charged as an domestic violence 2. That 2008 conviction involves a different victim. He has an assaultive record. He has, as I said, the 2008 aggravated domestic violence, a 2011 carjacking, fleeing elude, felony firearm, which he did prison time, and most recently a 2023 operating while impaired. Your Honor, people believe that even though he was found not guilty, there is prior allegations and found not guilty with the same woman. And here we are, and officers did observe injury. Based on this, Your Honor, and his background being highly assaultive, his carjacking got 6 to 10 plus 2. That's a big sentence on that. So, Your Honor, people believe that he is a danger to Ms. Duke. Obviously, they had contact again after September of 23. And people believe that she is in danger, so I'm asking for that 10,000 cash surety with the conditions of no contact. Thank you.
Thank you. Go ahead, counsel.
Judge, on behalf of Mr. Brown, I just would like to state my objection to the record to any amount of monetary bond. Any amount of monetary bond would be unaffordable. Judge, I do have an understanding of the severity of this case. I do see the age on the case. It dates back quite some time. And it's of no fault of Mr. Brown's. He's not been eluding this court. The warrant was just entered. So I don't have any reason to believe that he's a flight risk and cover that aspect of it. I believe that this court's concern and the people's concern is primarily if he's a danger to the public. Judge, I submit to this court that he's not a danger to neither the general public or the specific complaining witness. And I'll start with the specific complaining witness first. That is, to my knowledge, what's been indicated to my office, that Mr. Brown lives alone, has no contact with the complaining witness, has not had any contact with the complaining witness since his not guilty verdict in a prior case. And I actually think that not guilty verdict actually pays credence to Mr. Brown's claims of innocence on this matter. And I just would like to state that for the record. There's never been a rain on this case. He states to me that he believes, based on his knowledge, that the complaining witness doesn't even live in Michigan anymore. I don't take that and submit it to as fact. Just as something that has been indicated to my office, Judge. He does work. He's been a lifelong resident of the state. He has 6 children. He indicates to my office that he's a welder, 11 to 7 p.m. Monday through Friday. He's completed some college. And other than what's been stated on the record, I don't believe he's had any criminal interactions since his actual convictions last dating back to 2011. and his most recent not guilty verdict that he received on this complaining witness's allegations in the past. So for those reasons, Judge, the amount of time that's passed, the fact that they haven't been in contact in so long as he indicates to me, his lifelong ties to the community, I would ask you, Judge, to consider a personal bond on the matter.
Council Coyle, your recommendation or argument was for $10,000 cash surety, correct?
Yes.
Okay. And do you have anything new to indicate this is from November 2024? If you know.
Newest as to what? I'm sorry.
New, I mean, are there any notes or anything like that? I just want to make sure.
No, no new notes. But obviously they've had contact after the not guilty verdict because this is after the not guilty verdict. So they've had contact. So it seems to be this, if we look at the allegations, it's about her finding a condom in his bedroom. So obviously there was some issues as to their relationship. So I don't know if they're together. I can't tell the court if they're together, but this appears to be a type of domestic violence where they have children at least one child in common, that they seem to pull them together. So that's why I'm asking, because regardless of what the status of that relationship is, they have one thing at least that pulls them together, is that child. So that's why I fear that based on his assaultive background that dates back to 2008, that I and if she's not in Michigan, I have nothing to say that. I'm going to look at her statement.
Okay.
It says she's
Council
in
Coyle,
Michigan.
okay. I appreciate everything that you given me, and you gave me the information that I needed. Thank you, Council Coyle. I've heard the
You're welcome.
representations both sides. Court uses clear and convincing evidence standard when it's entertaining monetary bond. We start off with a personal bond basis. From what I see is that even though this is from November of 2024, he does have a prior domestic violence conviction, even though this is from, I think, 2008. And then he has assaulted conviction from 2011. Understanding he went to the Department of Corrections. Okay, not only that, but in this matter, supposedly the officers, when the complaint went to the precinct to report, make a report to the police department, is that they observed a busted lip, though the complaint did refuse medics. With all that being said, this is not a case that he has, this is a first time event of being accused of some violence. Okay, but I'm just looking at what's in front of me. Court does find that he is a danger. Court is going to adopt the recommendation, $10,000 cash surety. Okay, and I just want to make sure, Council Breakoff, this is unaffordable. Is that correct? Okay, so that means, Mr. Brown, you're going to get another court date this Friday, June 20th, 2025, 9 o'clock, in front of Judge McConigal, who's going to look at the bond amount and bond conditions. Do you understand that, sir?
Yes,
Okay. That concludes your arraignment, sir. What's your name, sir?
Rojas.
First name again?
My last name Rojas.
Rojas, or Rojas. Mr. Rojas, this is Magistrate Charteser. You're here on a criminal matter, case number 220-577-3301. Council Breakoff, you waive from a reading, stand mute, and has he been advised of his constitutional rights?
Yes, Judge, requesting not guilty plea be entered.
Okay. I'm gonna enter a plea of not guilty, and this is an AG case, which tells me that no Vincent and no Coyle will be appearing on behalf of the people. I'm gonna enter a plea of not guilty. I believe, let's see what we have. Court date is gonna be July 2nd, 2025. It is a probable cause conference. It's an in-person hearing, sir. It is at the Criminal Justice Center. Address is 5301 Russell, City of Detroit. 9 o'clock. The judge is Prentice Edwards Jr. Do you understand that? And with that being said, let's see, I'm required to have at least 25% child support or rearage. What do I have here? Will tell me. 19, almost 20,000. That means I have to do at least 5,000. Did you want to make any argument? Simply because this is from 2016, 2022, non-assaultive. Okay, so he's looking at approximately a $5,000 personal bond. Counselor, you want to add anything else?
Okay, I appreciate that.
Okay, $5,000 personal bond, sir. Nobody has to pay any money for you to get out of jail. Do you understand that? Go to court when you have to. That concludes your arraignment, sir.
Hey, I appreciate you so much. Thank you.
All right. Gentleman in a black, I think it's a black t-shirt. What's your name, sir?
No.
Is it Ronald Nassar?
No.
Nope. All right. Is your last name Didlake?
No, ma'am.
Nope. Didn't hear it.
Neil.
Ah, Neil. Okay. Mr. Neil, DDC?
Yes, Your Honor.
Okay. This is Damian Neal, right? Okay. DDC, Mr. Neal has a narcotic matter that he has to, after you guys are done with me, he has to log in with Judge Holmes.
Judge Holmes?
Yes, ma'am. And I'm gonna give you the ticket. Do you want the ticket number?
Yeah.
U72094625. Narcotic drug related violation. That guy's gonna have to zoom in with Judge Holmes. So with that being said, Mr. Neal, Damian Scott Neal, you're here on a criminal matter, case number 25058222901. Counsel Breekoff?
Judge, Miguel Brick on behalf of Mr. Neal, waives a formal written complaint, stands here requesting not guilty plea to enter on his behalf. He has been advised of his constitutional rights.
Thank you. I'm gonna enter plea of not guilty. Court dates are July 1st, 2025, probable cause conference, followed by preliminary examination, July 8th, 2025. Both matters are in front of Judge Taylor. Mr. Neal, can you hear me? Okay, please say your full name again.
Scott Neil.
Full name. I just heard Scott Neal.
Damian Scott Neil.
Thank you, Mr. Neal. Okay. David, court dates, bond conditions. You're not to possess any illegal controlled substances. Do you understand that, sir?
Yes, sir.
Okay. Counsel Coyle? Go ahead, ma'am.
Lisa Coyle appearing on behalf of the people. Your Honor, Mr. Neal unfortunately has a long history of drug and alcohol abuse. His last conviction was June 20th of 24 for an OWI 3. This is non-assaultive. No objection to a $10,000 personal bond in this matter.
Counsel Breekoff, no objection. Mr. Neal, you're gonna get a $10,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you understand that, sir?
Yes, ma'am. Thank you.
All right, that concludes your arraignment, and I know you're gonna go in front of Judge Holmes. Thank you. You can step aside. Sir, what's your name? You're gonna have to repeat it. Sorry.
Ronald. Last name is Nassar. N-A-S-S-A.
Okay, Ronald Nasser. Mr. Nasser, I'm Magistrate Charte. You're here on a criminal matter, case number 2505822-801. Counsel Breekoff, go ahead, sir.
Judge, my client, Judge Miguel Brico, on behalf of Mr. NASCAR, the client's been advised of his constitutional rights, waives a full written complaint, stands mute, requests that this court enter a not guilty plea on his behalf.
Thank you. I'm gonna enter a plea of not guilty. Court dates are June 27, 2025, probable cause conference, followed by preliminary examination, July 3rd, 2025. Both matters are in front of Judge Jefferson. Mr. Nassar, can you hear me?
Not what I want.
Okay, if you can hear me, I gave you the two court dates, and if you understood court dates, you can shake your head.
Won't remember them. I
I wrote them down.
You'll get them also in writing from one of the officers. You'll get some paperwork telling you about the court dates. Do you understand that?
You understand that this is not what I want.
Okay, Mr. Nassar, is not whether you want it or not. We're going to arraign you. I'm making sure that you're aware of both court dates, June 27th and July 3rd. Do you understand both, sir?
Years that she has it written down for me, because I'm not gonna remember. I don't even know where I'm at right now.
Okay, all right. Mr. Nassar, you're at the Detroit Detention Center. It's a jail, it's a holding facility. Whether or not you get personal bond or not, that will be determined later, but I want to make sure that you are aware of the court dates. The first one is June 27th. It's at 8:30 in the morning. It is by Zoom in front of Judge Jefferson.
Here by Zoom.
It is by Zoom in front of Judge Jefferson, June 27th, 8:30 in the morning. Do you understand that, sir?
Someone be taking me there.
Pardon me?
Someone be taking me there.
I'm sorry, I didn't understand you, sir.
Will someone be taking me to that gate?
No, it is by Zoom. You have to zoom in. It is by internet.
I don't have internet, and I wouldn't even know how to work it if I did.
Judge,
Go ahead, Council Brickoff.
Judge, just on behalf of Mr. Nassar to explain some of the issues we're having right now. My client does suffer from Alzheimer's, Judge. He has memory issues, and I believe this may contribute to some of our issue today. So I just wanted to make that.
Okay,
clear.
all right. Council, does your client have a guardian?
No,
That-
Judge, so, it's just a sad case, Judge, to be honest with
Okay,
you.
so no guardian.
No guardian.
Okay, all right.
He'd rather stay in the
All
jail.
right. Mr. Nassar. Can you hear me, sir?
Ma'am,
Do you have any family members?
no,
Do you have any friends?
no.
Mr. Nassar, the only thing I can tell you, sir, is that, okay, you have to be in front of, and you may want to come in person, but you have to be in front of Judge Jefferson. And you will have an attorney. Do you have any information how to contact him?
No, Judge. That was gonna be part of my argument for you today.
There is no one, you don't know how to contact him or anything like that?
Judge, he doesn't have a phone and email, no family members, no relatives, no friends.
Does he have an address?
Yeah, he's provided us with an address, but Judge, I believe it's the address that this arson case is revolving around, so I don't believe that that's the address that he may return to.
Okay.
And
Mr. Nassar. I suggest, sir, you come to court on the 27th or contact the court, Judge Jefferson, for your court date of June 27th. Do you understand that?
Somebody's gonna have to do that for me. I have no telephone, I have no address, and I'm here. This is my home for right now.
Okay. Well, my understanding is that you live on Griggsdale.
I'm sorry.
So, my understanding, you live on Griggsdale, Mr. Nassar, so you have to find a way to make contact with the court. Do you understand that?
A little loud, just a little loud.
Where's the microphone? Maybe
Okay. Mr. Nassar, can you hear me or do I need to speak louder?
You can't hear me, is what the problem is. Can you hear me better now?
I can hear you better, Mr. Nassar.
Have
So,
no-
Mr. Nassar, you have to come to court on the 27th of June. Judge Jefferson. I suggest that you come early and see if you can change that to an in-person or by Zoom and letting the court know in terms of your conditions of, you say you don't know how to work Zoom, you have no phone. Do you understand that, sir?
My address for right now, where I'm at. This is my home. They would have to provide me transportation. I don't even know how to get to where you're talking about. I don't drive. I don't have my glasses. I don't know what else to tell you. Pick me up and take me wherever you want. I already told the lady before, what I really think the smart thing would be is to euthanize me and to forget all of this nonsense.
Well, sir, I don't know about that nonsense. Are you suggesting that you want to stay in custody?
Yes, I have nowhere else to go.
All right.
I'm
So, all right, so Mr. Nassar, from what I understanding, and we'll let your attorney argue, but you are saying that you want to stay in custody?
I have nowhere else to go.
Okay, Mr. Nassar. Council Vincent?
Magistrate Steve Vincent for the people, P 71917. We're dealing with a desperate individual. He allegedly burned his house down because admittedly he wanted to go to prison because he doesn't have anybody in his life, and apparently his faculties are starting to deteriorate. I don't want to be accused here of being incompassionate, but there are a few things that I need to get on the record. This defendant, for over a year, planned on allegedly burning his house down
Only
in a
unfairly. This was more than that. This house was.
Mr. Nassar, Mr. Nassar, don't say anything, please. Don't say anything. Let the attorney for the people speak, and you still have a right, but don't say anything because everything is being recorded. Do you understand that, sir?
I want him to be correct in what he's saying. That's all
Sir, you don't need to correct anything. You'll have the ability to talk to your attorney at a later date. Let the attorney for the people speak.
This was a plan. It was schemed. He had accumulated kerosene over a certain amount of time and then ultimately ended up setting this house on fire because he was going through eviction proceedings and knew he was going to lose the house, meaning he was not going to have anywhere else to stay. So apparently he thought if he burned the house down, he could go stay in prison. The entire time putting not just himself, but the community at risk. Now, I can appreciate the fact that this defendant talks about going through Alzheimer's. I personally have had family members that have gone through it, God rest their soul. But this shows all indications that he was cogent throughout this process, planning something, speaking with people. As you can see, he can have communication with others just fine. And as we heard from this defendant, he is desperate. He doesn't have anywhere else to go. I think he went so far as to just talk about ending his life. So the desperateness now is a danger to the community on a multiplicity of reasons, but just for the reasons that we're here, setting a house on fire in a residential area where it could have hurt just not only himself, but the surrounding premises and anybody else that were in those premises. So I'm going to be asking for a $30,000 cash surety bond. I'm not going to be asking for a tether because there's no need. There's no place that he can apparently go to. But this, unfortunately, we're at a point, and I don't know how far along he is, but at least in terms of the medical response, when he had to be submitted to for a mental health check, he checked out. He checked out with them. And they said that he wasn't having an episode when he performed this alleged incident. So we do unfortunately find him to be a danger. We find him to be a danger because it's apparent he is desperate. He has nowhere else to stay. He has no means of communication, and we don't know what else he's capable of. So that's why we're asking for the cash bond.
Thank you. Counsel, go ahead, sir.
Judge, on behalf of Mr. Nassar, I would ask this court to impose a nominal cash bond. Mr. Nassar had a discussion with our office, does not have an address to remain at, does not have a phone number to provide us with. We are currently looking into resources to provide him with at the next time we speak through these video conferences, Judge. He does have Alzheimer's, and this is a sad case, Judge. I have personal experience with it as well. We're all going to get old. I hope that it's kinder to us than it has been to Mr. Nassar. I understand he's passed that mental health evaluation at the time. This is a disease of the brain. We are litigators. We don't know when you come in and out of cogency on matters such as these, Judge. I would ask for a nominal bond, and that's where I stand.
Thank you. Court heard the representations, both sides uses clear and convincing evidence standard when it's entertained monetary bond. Your client just said that he has no place to go.
Right.
But aside from that, that's not what the court looks at. The court looks at, one, is he a flight risk or is he a danger?
Right.
Flight risk, I don't see him as a flight risk, but he has no residence to go to. But from reading the allegations in the investigator's report, supposedly that this was planned. Supposedly that this was planned. So that's the allegations. So by supposedly him, okay, saving for him to save kerosene, to hoard it, and then to start a fire, and supposedly it's deliberate. I don't know. Okay, that's for a trial court to deal with. The court does find that he is a danger. The court is going to adopt the recommendation, $30,000 cash surety. Mr. Nassar, you are going to get another court date for this Friday, June 20th, 2025, 9 o'clock in front of Judge McConicle, who's going to look at the bond amount and bond conditions. And Mr. Nassar, let me also say, sir, you're not to possess any flammable liquids of any kind. That concludes your arraignment, Mr. Nassar.
Thank you.
Judge, may we request DDC to mark this medical?
Yes, DDC, can you mark Mr. File medical?
Yes, Your Honor.
Thank you.
No problem.
David Dillay.
Mr. Deadlight, sir, this magistrate at Chapter, you hear criminal matter, case number 250-5822701. And is it David Wesley Deadlight, sir?
No, just David Dillay. I don't have.
Okay, sir. All right, because I have you as also as David Wesley Deadlight. Anyways, you have an attorney. Counsel, do you waive formal reading, stand mute?
Yes, Judge, my client's been advised of his constitutional rights.
Thank you, counsel. I'm gonna enter plea of not guilty. Court dates are June 26, 2025, probable cause conference followed by preliminary examination. July 3rd, 2025, both matters are in front of Judge Giles. Mr. Didlake, while this case is pending, 1, you're not to possess firearms or any other dangerous weapons. 2, you're not to have contact with Yakina James. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. And let's see if there is address. Okay, go ahead, Counsel Coyle.
Lisa Coyle, appearing on behalf of the people. The people are recommending a $500,000 cash surety bond. And for the following reasons, Your Honor, Mr. Didlake allegedly came over to the complainant's home in a U-Haul with another female, asked about her owing some money. She told him to leave. He punched her, grabbed her by the throat and choked her, and then took a necklace from her. the other woman there began to pull Mr. Didlake off the complaint yelling, "Let's go." They leave and then they come back a few minutes later. And then Mr. Didlake says to the complainant allegedly, "You think this is a game?" Then he pulls a gun, he racks it, and he fires a shot into the complainant's leg. Then he stood over and put the gun to her head. The other person with Mr. Didlake said, "Come on, let's go," and they take off. And the reason I'm asking for such a high cash surety bond, not only because this is the acts of somebody who's just reckless and dangerous based on just that alone, but that he was just currently discharged from parole October 27th of 24. He has a long assaultive criminal history dating first back to 2007, which under height of status, he had a couple delivery cases. And then I note in 2014, domestic violence, a 2016 great bodily harm conviction, a 2017 great bodily harm unlawful imprisonment conviction, and a 2017 animal killing and torture, as well as an R&O conviction. Your Honor, this Mr. Didlake is all of 35 years old, and he has been for the last 10 years in prison. And so he just got out in October of 24. So we're talking less than a year. And then he blatantly comes over basically to collect money. And this is a warning when he put a shot into her leg and stood over her head with a bullet. This is control. He is a danger to the community. And so that is why I'm asking for such a high cash surety bond, because he not only poses a danger to the complainant, but to everybody else. Thank you.
Thank you. Go ahead, counsel.
Judge Miguel Rico on behalf of Mr. Didlake. I understand the severity and the seriousness of the allegations against my client. My client is presumed innocent unless proven guilty beyond a reasonable doubt as to all these matters. Judge, on some factors of his background, he is a lifelong resident of the state of Michigan. He does have 3 children. He does live with his girlfriend at the current moment. The address in which this incident occurred, the address in which the complaining witness resides, is not the same address as where Mr. Didlake resides. I object any amount of monetary bond on this matter. The amount of monetary bond would be unaffordable for my client, would operate as a pretrial detention on the matter. Judge, instead, what I'm proposing, because I understand that this court has an obligation in keeping the community safe and in ensuring that this defendant reappears in court, I'm proposing to this court to allow Mr. Didlake to exit the DDC today on a personal bond, but with a restriction of home confinement. I believe that this condition alone will keep the public at large safe, will keep the complaining witness safe, but will ensure that Mr. Didlake does appear for court, because if he does not, he's going to get picked up. So I would suggest to this court that we do that in this situation. My client does not work. This will not affect his work. He's on disability. He does have many medical issues in which we are going to mark him medical in the DDC today for if he does not leave. He does have a GED. These allegations will be litigated at a later date. I don't like to touch on the factual portions of them because they are just allegations, Judge. That's my request to this court, and I thank you for hearing my argument.
Okay. Counsel Coyle? I just want to make sure. He's got at least 2 prior felony assaultive convictions within 15 years. Is that correct?
He does. He could go for a remand on this.
But
So
you're not asking for that.
Then I will change and let's go for a remand.
Anything's changed, Counsel Coyle, from when you asked for a monetary bond to a remand?
Your Honor, because when I looked at it, I to be honest, I was appalled by this case. So I didn't automatically think of a remand. I'm sorry, based on.
That's right.
But it's not. It is. I'm looking at the statute right now. It is a violent felony. It does have. He's been convicted 2 or more, and that the evidence of his and presumption is great as to the allegations, Your Honor. So remand is more appropriate. I guess they're both doing the same thing, and it's a bond that's going to be something that keeps the community safe.
Thank you. Counsel Brickoff, because now she's changed her argument to a remand status. What's your further argument, sir.
I understand, Judge, and I understand why we can use the remand here, why the people can suggest that because of what is authorized under the statute. I still stand by my original position, Judge. I believe that looking at the two factors we consider can be accomplished by this home confinement personal bond matter. And that's where I would stand, Judge. I would request that we do that. And cash surety, the remand, they both operate the same way for my clients, Judge. They're both going to operate as pretrial detention no matter what. But it's unaffordable. So I wouldn't
Okay.
ask for personal bond home confinement.
All right, thank you. Courts heard the representations, both sides. This particular matter uses clear and convincing evidence standard when it's entertained monetary bond. We started off with personal bond basis. Prosecutor has argued for monetary bond, then made, when I pointed out that he has at least 2 prior felony convictions are assaultive, she's changed it to a remand. The only difference between a monetary basis and a remand is that there is no bond redetermination. The court has read the allegations in the investigative report. The court does find that Mr. Didlake, he is a danger. He has assaultive prior conviction. The court does believe specifically under Rule 6.106, which is B1A 2IB, during 15 years preceding the commission of a violent felony, the defendant has been convicted of 2 or more violent felonies under the laws of the state. And they're separate, separate incidences. And if court finds proof that his guilt is evident or presumption is great, the court does believe that his guilt is great, presumption is great. Okay, so in this case, he's going to be remanded, no bond redetermination.
Your Honor.
And Mr. Didlake, let me say this, sir, is that whoever your attorney is, discuss with your attorney about the issue of your bond status, who can approach Judge Giles. Do you understand that, sir?
Yes, but can I say a few
Okay.
things? And
Sir,
not-
you can, just let me say this, Mr. Didlake, you have the right to speak. The court is not going to say you don't. You have the right to speak. But if you say anything, everything is being recorded and can be used against you later on.
You understand, I just want to go over the facts that the prosecutor used, including about the residence where the incident took place. There was no one has a residence there. That was just a abandoned place where people gather at and drink and do intoxicants. That's one. But 2, at the time when I was arrested in 2016, I didn't get released until 2023. So between that time, 2017, I should not have had an offense that led to me getting another assault case. Secondly, this case with the detectives that I spoke with also coincides with the case that they wanted me to be a witness because I was a victim of a crime as well due to the same people. In the interrogation, it was explained that because they brought that matter up into this matter. That's one thing I wanted to say. I have never had that period of time from 2016 once being incarcerated to 2017 having another offense on me in prison. My prison record speaks for itself. I haven't. Now the other cases of sort of matter was about the dog situation. And I was never convicted of another assault of crime that hindered me from being able to be released. The assault great bodily harm, was coincided with 2 parties, which I protected myself. Nonetheless, I only received a probation status for that, a non-reported probation status for that. Other than that, my actual assault of crime that I was convicted for, I did time with in 2016 to 2023. After that, I was a victim of a shooting. I never was convicted of another assault case.
Mr. Didlake, let me say this, sir. Everything that you've said is on record. What I do suggest is that you talk to your attorney, okay, and that your attorney can approach Judge Giles about your bond status. Do you understand all that, sir?
The only reason I was repeating is because I wanted to make sure that I had a clear understanding of what the prosecutor was accusing or saying what my file was, and I had an understanding of, I wanted to be on record on of the
Okay.
thing.
All right. Okay, thank you, Mr. Didlake. Everything is on record. Thank you, sir. That concludes your arraignment.
stand right here.
Judge, my office has yet to make contact with the hospital Parham.
Okay. Sir, what's your name? Did you say it's James Vaughn? Mr. Vaughn, James Arnest Vaughn, sir. I'm Magistrate Chartea. You hear criminal matter, case number 250-4549-001, sir. You have an attorney. Go ahead, counsel.
Judge Miguel Brief on behalf of Mr. Vaughn appearing today via Zoom. My client's been advised of his constitutional rights, waives of formal written complaint, stands mute, respectfully request that this court enter a not guilty plea on his behalf.
I'm gonna enter a plea of not guilty. Court date is June 30th, 2025, pretrial in front of Judge Jones. Counsel Vincent, go ahead with your argument, sir.
No argument here, Magistrate. We're not going to object to a personal.
Okay, so Mr. Vaughn, you're gonna get $1,000 personal bond. Nobody has to pay any money for you to get out of jail. Just go to court, handle your matter. Do you understand that, sir?
Yes, ma'am.
Okay, that concludes your arraignment, sir. You can step aside.
Judge, what was the amount of
$1,000 personal bond for Mr. Vaughn.
Thank you, Mr. Vincent.
Ms. Marcia,
Yes. What's going on?
this one, supposedly this person is in the hospital. We haven't heard anything.
Did you guys speak to them?
Parham.
The hospital, with Parham?
No, the officers at BBC said that they let DPD know and stuff, but they didn't hear anything back, so no, they didn't make, there's no like officer.
No officer
contact,
there to
nothing.
zoom on with their phone or nothing?
Nobody gave us any.
Okay, well then,
Okay. Then you can have that.
Yeah, I'm gonna take this back to Denise.
Okay.
I'm signing this remand.
Yes, ma'am.
So for Parham, I'm about to take this back to Denise, scratch it up there, scratch it up there.
Sure. EDC.
Yes.
My understanding is, were you aware that Eric Tracy had another case?
Yes.
Okay. I believe he's the only male that we have left.
We've been waiting on him to be interviewed by Mr. Phil, and we can't get in contact with Mr. Phil.
Mr. Tracy.
He's already been interviewed.
Okay, he was already interviewed?
Yeah, he was told about this. He had 3 cases this morning.
Okay, and he's got this 4th case.
Yeah, he's ready.
Okay, so you can put him in front. My understanding that he's already been interviewed.
Thank you.
4, 9, 6, 2. Does he have the same court date? Does Eric, Skelly? Eric Tracy, he was arraigned this morning. What is his court date from this morning?
1 second, I got it.
Okay. Mr. Tracy, this is Magistrate Chartea. You have another criminal matter, case number 99064962001. Counsel, do you wait for him to read and stand mute on behalf of Mr. Tracy?
Yes, Judge, and he's been advised of his constitutional rights.
I'm gonna enter a plea of not guilty. Mr. Tracy, let's see what this is. Sir, you're not to go to any Wayne State areas. Do you understand that? Okay. Officer Kelly, can you tell me? Still looking.
Just for what it's worth, my paperwork documents 6:30.
6:30? Okay, I'll go with that. That's from this morning.
Yes.
Okay, so Mr. Tracy, your court date is June 30th, 2025, pre-trial. Doesn't say in front of who. Let me see if I can have some paperwork that says it. In front of Judge Jones, Mr. Tracy, along with your morning cases, this case, June 30th, in front of Judge Jones. Do you understand that? Counsel Coyle?
Lisa Coyle appearing on behalf of the people. No objection, 5,000 personal.
Sir, you're gonna get a $5,000 personal bond. Nobody has to pay any money for you to get out of jail. That concludes your arraignment, Mr. Tracy.
If I need it.
Okay, all right. So DDC, I'll see you on the female side.
Okay, thank you. Your Honor, what happened to Mr. Parham?
Mr. Parham supposedly is supposed to be in the hospital. We haven't had no contact with Mr. Parham or the hospital. Nobody has zoomed in. So they're probably gonna do it tomorrow.
Sounds excellent to me. Thank you.
Thank you. And then let's go. We have female, I believe, one. Ma'am, what's your name? Can you hear me, ma'am? Can you see me? Well, somebody needs to unmute so you can talk, so we can hear you.
Can you hear me?
What's your name, ma'am?
Rebecca Ann Davis.
Ms. Davis, this magistrate at Chuck Batten, not only do you have a criminal matter, but you also have a misdemeanor matter where you did not show up for court. We're gonna recall the warrant. You're gonna get a personal bond. Nobody has to pay any money for you to get out of jail. Maximum penalty is up to 93 days jail and or $500 fine. Gonna enter a plea of not guilty. Ticket number 753964. No operator's license on person. Court date is July 8th, 2025. Pre-trial in front of Judge Sherman. Ms. Davis, you have a right to remain silent. Anything you say, orally or writing, it can be used against you in a court of law. Right to an attorney, have that attorney present during questioning. If you're unable to afford an attorney, one will be appointed for you, court expense. Understand those rights, ma'am? Is that a yes?
Yes, ma'am.
Okay, thank you. That takes care of your misdemeanor matter. Criminal matter, case number is 250-582-1701. Please say your full name again.
Rebecca Ann Davis.
Go ahead, counsel.
Judge Miguel, brief on behalf of Ms. Davis, my client's been advised of constitutional rights, waives formal reading of the complaint, stands mute, requesting not guilty plea be entered on her behalf.
I'm gonna enter a plea of not guilty. Court dates are June 26, 2025. Probable cause conference followed by preliminary examination, July 3rd, 2025. Both matters are in front of Judge Giles. Ms. Davis, you're not to possess or use any illegal controlled substances. Do you understand all that?
Yes, ma'am.
Okay. Counsel Vincent, go ahead with your argument.
Thank you, Magistrate. Good afternoon. Steve Vincent, P 71917. The defendant here does have a bench warrant out of the 18th district. I believe it's Allen Park for narcotics. She failed to appear at a pre-trial December 18th of last year. There's a $3,000 cash surety out for her. Here, no capious history. She's being arraigned for the first time. Any danger here, I think, is just to herself. It's a meth case. Respectfully, we're not going to be objecting to a personal bond with that, no drugs.
That being said, Ms. Davis, you're gonna get a $5,000 personal bond. Your attorney's not objecting. Nobody has to pay any money for you to get out of jail. You understand all that, Ms. Davis?
Yes, and does that mean I'm free to go?
On this case, however, if you have other cases with monetary bonds, you have to deal with those cases in those district courts. But today you get a $5,000 personal bond. Thank you, Ms. Davis.
Thank you.
Have a good day. BBC, thank you very much. You have a good day also. Everybody else, have a good day.
Thank you. We will see everybody Friday.
Yep, that's
Yes.
right. Thanks, Magistrate. Thanks, Madam Clerk. All right, talk to you later.
Okay.
All right, bye.
Okay.